Hi, my name is Michael Burgis, and I'm a legal certified specialist in California workers' compensation. I'm the managing attorney of MB&A. We are a firm that represents California workers' compensation, employment law, wrongful termination, retaliation, discrimination, sexual harassment, and catastrophic civil liability. I wanted to create a video to educate the viewers on some case law. Below is a link to a case of Benson apportionment. That video is sort of a precursor to this video, so I strongly suggest you watch that to have the fundamentals for this video. But I want to discuss a case called Herrera versus Maple Leaf Foods or U.S. Fire Insurance Company. This is a workers' compensation panel decision. This case really just solidifies the exception to Benson and the holding in Benson. So remember, Benson says that a physician should address apportionment amongst multiple industrial injuries, and if that physician can apportion amongst those multiple injuries to a, quote, reasonably medical probability, end quote, then the injured worker is entitled to a partitioning of the overall disability, which harms them monetarily. Now, this case, Herrera versus Maple Leaf Foods, really just confirms that a physician finds that the apportionment amongst multiple industrial injuries is inheritably speculative or, quote unquote, inextricably intertwined, and this physician can justify this and explain the how and why, and that medical evidence constitutes substantial medical evidence, then the injured worker is entitled to an unapportioned award, meaning compensation based upon one date of injury. Now, remember that compensation for disability based on one date of injury is going to provide more money overall than if it's partitioned out to multiple dates of injury. So this case, Herrera versus Maple Leaf Foods, is something that we've been arguing since day one of Benson apportionment, and this case just confirms it. And once again, this case is one of the many cases that's interpreting Benson apportionment, including a very important noteworthy panel decision called Dileva versus NORTHROP GRUMMAN, link below, which is my firm's and my personal case that we litigated. So I hope this quick case tutorial has been helpful. If you have any questions or concerns, if you are an injured worker, and you have multiple dates of injury, it is extremely important that you get an attorney, because an attorney needs to understand apportionment, Benson apportionment, and the exceptions to Benson apportionment of whether it's, quote unquote, inextricably intertwined, as well as the case of Dileva versus NORTHROP GRUMMAN regarding multiple physicians and Benson apportionment. It is hugely important, because if you watch my video on Benson apportionment, it has real life impact on injured workers, from 5% loss of income, 10% to 90% loss of income in some hypotheticals. So if you have questions or concerns, please get an attorney. We're here standing by. Feel free to give us a call. Thank you.